all, I think that it's really important to refer to the Administrative Justice Act and also the constitutional provisions now that entrench administrative justice. But I think there is still a problem with the Administrative Justice Act itself, because I think there are aspects of the Act that are unconstitutional in the sense that they take back some of the rights in a way which I think is not justifiable. If you actually analyze the Administrative Justice Act, I think there are provisions in the Act itself that need to be changed to be consistent with the Constitution. Secondly, the enforcement of court orders, I think, is, as you pointed out, so important. The fact that the court order is abided by and is in fact implemented really is of the essence when it comes to the rule of law, as you pointed out. Can you just comment upon the efficacy of threatening contempt of court, and now also the judgment that has come out on the possibility of attaching state property in satisfaction of a debt that hasn't actually been paid by the authorities? In other words, that the litigant, if they cannot get satisfaction through the courts, can now proceed to actually go forward and try and attach state property.
The administrative, the act that I referred to, I agree with you, but I think the process of aligning with the laws should actually address all those issues, and I think the citizens should be more sorted. That's what I would say. Coming to the other point, that's the issue of state property. It's a bit. I ruled in one case that the bus belonging to a school. I haven't seen the appeal. We are tasked. The argument was it belonged to the Ministry of Education and whatever. I think there is need. I agree with the government. I can't remember the judgment. I can't remember who delivered the judgment, but I think it was Zanu, where they're saying state property can be attached. Okay, if there are limitations, it is time the government started. But they should not disobey court. They should then come in with legislation which will protect them rather than disobey court. That's where I have a problem with the executive. Did I leave out?
No, that's fine. Thank you.
Yes.
Thank you very much, Retired Justice. Okay. A very insightful presentation on the rule of law. You made a very interesting comment, and I mean, I think it's a comment about whether the judiciary is captured by the executive or not, and it's encouraging to hear what you say, particularly from someone who has been inside and who is outside. There is a view, though, and I think we can't dismiss that view, but there is a view that how the independence of our judiciary is seasonal, in the sense that there is a particular point in time when the judiciary is robust and hands down judgments that are impartial, particularly when they are dealing with matters that do not necessarily involve politically sensitive issues. But when matters that involve politically sensitive issues come before the judiciary does not exhibit the usual independence. I say it is a view, and I think it's based on quite a number of judgments. You look at different points in the history of this country. I mean, lately, of course, look at Jealous Mawada. I think it's a highly contentious judgment, where I think there's a view that the judiciary was not, the majority of the judiciary was not impartial, did not uphold the law. Then if you look at the, I think the other application that was made by, I think it's Morgan Tsvangirai versus President Mugabe, where he, I think, an election petition was brought after 2013. And despite the Constitution not saying anything about whether, or the rules of the court saying anything, it is claimed whether you can withdraw an application or not. I think the Chief Justice and the court refused that the applicant cannot withdraw from the matter. And I think it was a contentious decision again. But then when you fast forward, Mzuru, or is it Mabzuru versus Minister of Justice, the judgment that banned or that outlawed child marriages, it was a robust judgment. Again, the accusation is not a matter that really touches at the nerve of political power, and therefore the judiciary is able to exercise this or exhibit this robustness. I just want to know what is your view about this in response to this, because I think it's a concerning perception, especially given that the independence of the judiciary, as you rightly put it, is a pillar that is supposed to be very strong. We are to be a society that is based on the rule of law, but when the judiciary is sort of seasonal in its independence, it is concerning. But I want to know what is your view?
I would say in our environment, it is very difficult for the judiciary to be perceived to be independent, for the simple reason that we live in a polarized environment. So whatever decision the judiciary makes, as long as there is a political connotation, it's very likely that the judiciary is going to step on somebody's toe. And wrong or right is likely to be lambasted. Then the second thing, Judge, probably it's a bit sensitive, but I was just wondering, during your tenure as judge, would you say you were happy with the distribution or allocation of cases, say by the judge president? Would you say the allocation or distribution of cases was fair and objective, or maybe the judge president from time to time would take into account the sensitivity of the matter and allocate it accordingly?
Deviates a bit from what the other contributors raised. I observed, retired judge, from your presentation that you focused mainly on the rule of law as it pertains to the role of the executive and the judiciary. And I didn't hear much with regards to the rule of law vis-a-vis the parliament. Now I'm saying this, and I'm quoting Professor Maduku during a similar public lecture when he said, law is not law just because the parliament says it's law. He then went on to say, law is law only if it meets certain minimum thresholds which allow for fairness and justice to prevail. And to him, the role of the parliament is not simply to pass laws even if they are bad laws, because bad laws, according to him, would lead to perhaps some form of denigration of the whole concept of the rule of law. So my question, therefore, is, would you think that perhaps there is a specific role of parliament to ensure that the laws that we pass do indeed meet the minimum tenets which enable the law to be able to achieve a just and free society?
In terms of the sort of value system of the law, that an incredibly bad law which is oppressive cannot be deemed to be in conformity with the rule of law. I think there's another supplementary aspect attaching to it. Sometimes you can pass a law that sounds reasonable and good at face value, but if it's misapplied, wrongly applied, then you also have a breach of the rule of law. So if you have a situation where you pass a law which at face value appears to be reasonable, but the way in which it's been applied is, say, applied on a politically biased basis, then does that satisfy the rule of law?
Mr. Hogwe, you spoke about the polarization in our situation. I think I'll just agree with what you're saying. Our situation is so polarized. On the distribution of and allocation of cases, I want to say retired, though I remain a judge, some of the things I said should be said in a guarded manner. I got those cases that I got, and mainly because I had been in the labor court, I took it that I was given certain things that related to that because of that experience of my having been in the labor court. But in general, it's a bit difficult for me to comment on that. I appreciate it. Thank you very much. Nyasha. Yes, Nyasha, you asked about the role of Parliament. I did indicate that really it's the three arms of government working together. And I would have put the role of the Committee on Legislation currently led by Sam Kanye is meant to address precisely what your concerns are. And we all take it like these are elected representatives, and we expect them to pass laws that are in keeping with the interests of the people and the rights of the people. Misapplied laws, bad laws being misapplied. Again, I think same comment I would make. I can't go any further than that. I think our parliament should be robust enough to, but I mean they can only do that. There are not very many new laws that really are coming out of Parliament introducing new laws. It's generally the executive that will take back to the polarization that was referred to. And then nobody can stop that because maybe the ruling party has the majority and whatever you're saying, other people are just with him. That's the problem.
Thank you very much, Judge.
Former Chief Justice of Swaziland, Ramo Debate, Justice Chinengo would be very knowledgeable about that case. I think what he did is that he was accused of having failed to properly declare his income, and therefore he evaded tax, right? Payment of tax. So he was basically sued by the Revenue Authority of Swaziland. And there is nothing wrong with the High Court in terms of the act, the act regulating such matters. There was nothing really wrong with the High Court of Swaziland hearing that matter. But what was wrong was that the Chief Justice allocated the matter himself to another judge. So in that case, I think that's when we would say justice was not seen to be done. But I think if the JSC brings the matter, and because the Chief Justice and the Deputy Chief Justice are conflicted, they allow, I think there's a hierarchy, Judge, isn't it, in the Constitutional Court, or in the High Court, or in the Supreme Court. And they allow the next highest ranking judge to perform those roles. I think it works. So I don't think there's nothing.
For these and other stories, visit our website www.263chat.com. Follow us on Twitter @263chat and like our Facebook page 263chat.